All right. Well, as I said, good afternoon, and on this rather sunny Friday, thank you for taking the time to come and join us. Can I thank Ian Cain, who's joining me today? I'm Oliver Newman, per the presentation notes. Ian has stepped in very kindly as Joanna Gillen, who was down to present this with me. Unfortunately, has some work's come in, and she's got a case that she needs to do some advice on. So today we're going to look at neighbour disputes. So we're all spending far more time than we might usually have done at home, in close proximity to not only our families, but also those we live near. And of course, any situation like that can lead to friction. So inevitable that sometimes that will lead to friction, that will lead to legal problems. And these can take many forms, but the most common really are noise nuisance, disrepair type issues, harassment, can be boundary disputes and rights of way disputes. And in this talk, we're just going to run through a little bit on each of these, some in a bit more detail, some in a bit less, and talk about the particular features of causes of action under these different headings, a little bit on remedies, and we'll conclude just by talking a little bit about interim injunctions, as those are frequently thrown up in these kind of cases. But firstly, if I can just throw this over first to Ian to speak a little bit about noise nuisance.
Thank you, Ollie. So looking first of all at noise nuisance. So when we're discussing nuisance in this context, it's going to require the interference with a neighbour's quiet enjoyment of their land. The key point to always bear in mind is that that nuisance must be both substantial or unreasonable. It can arise from either just being a single incident of particularly loud nuisance irritation or through an ongoing state of affairs. And it can be caused by an inaction or omission, as well as there being some form of positive activity. By inaction, we can look at things like if you hire builders to come into your property, they are making unreasonable levels of noise that would not normally be required. If you fail to stop them, ultimately you could find yourself in trouble. The broad unifying principle is reasonableness between neighbours. Of course, it's very natural if you're living in a large block of flats, you do have to expect that there is going to be noise caused between different neighbours. Question is then, when that goes too far? The interference itself must be reasonably foreseeable. And what we mean by that is if you're a homeowner and you're particularly sensitive to noise, and that noise would not be reasonable to an ordinary individual, it cannot be deemed to be reasonably foreseeable that that would cause you a nuisance. When we're talking about a noise nuisance, I do think of a case in which our very own Oliver Newman dealt with a few years ago, which involved somebody, a teenager, who was swearing and shouting and getting particularly angry at a video game which he had been playing for nights on end, and by night also into the early mornings. So now that we know what noise nuisance is, we have to dive a little bit deeper into the question of what is reasonable. In order to decide whether there's been a nuisance, the court will have to consider reasonableness. And this will depend on particular factors that are raised by the particular circumstances of each case. The first thing that the court will usually consider is the location of the building. I had a case last year where it took place in Muswell Hill, and the judge, by sheer chance, lived 3 streets away from the property in question. And he described the area as being as dead as a doornail. Of course, if the property is next to a particularly busy major road, it's to be expected that there is going to be more noise present than an area which is as dead as a doornail. The time the nuisance keeps occurring is going to be a relevant factor. In particular, if the nuisance keeps happening in the middle of the evening when most people will be expected to be asleep, the court is more likely to find that there has been a nuisance. The frequency and intensity of the noise will be taken into consideration. The louder it is and the more regularly it keeps happening. The question the court will ask itself is how that noise would impact a reasonable claimant. And unusual levels of sensitivity, as I mentioned earlier, will not help with a claim. Is there any suggestion that the act itself is malicious? If it's very clear that somebody is causing this nuisance at particular times, based on an ongoing relationship between them and the neighbour, the court's much more likely to find that there is a nuisance if it can be shown that that act keeps being done maliciously. So after the court has considered what is reasonable in the circumstances, we have to ask ourselves what are the steps we can undertake in order to prove that there has been a nuisance. Well, in terms of, first of all, collecting evidence, noise nuisance claims will usually involve ongoing or repeated issues. We are very fortunate to live in this modern age where most people will have mobile phones, and practically all mobile phones will have some form of recording capability as a result of their built-in microphones. So it's strongly advised that your client take a recording of the noise, of the nuisance, to make sure that that evidence can then be played to the court to provide them with an example of exactly what the nuisance is that they are facing. In particular, if the nuisance is ongoing over periods of time, it is very well worth the client keeping a diary recording of the times, the durations, and also the impact upon the household which is being caused by that noise nuisance. When we talk about the impact in particular, if it was a case where a witness statement was created in the standard course of litigation just before a trial, and within that witness statement, the claimant says, oh, this was really terrible, it was particularly annoying, I remember that it caused me great difficulty. It's going to be even stronger evidence if you can point to a particular diary entry which has been created live or closer to the time in which the nuisance was caused, and show directly the impact that the noise was having. If, for example, it's a noise which takes place at night and it's causing a young child to remain awake, or a baby to start crying as a result of a loud noise, then the court's going to take that into consideration for the nuisance. If you report the noise to a local authority or a landowner, not only will the local authority and the landowner be able to provide you with additional evidence if required in way of a witness statement or an explanation of the steps they've undertaken, the notice that you have sent to the local authority or the landlord itself will also be deemed by the court to be evidence. In the vast majority of cases where we're looking at noise nuisance, you will need to have expert evidence, where an expert will be required to comment on things such as the decibel level for the noise and what a reasonable limit would be in normal circumstances. It's very important as well to consider the other options that your client may have beyond court proceedings. Next Tuesday, myself and Adam Gersh will be presenting a webinar on alternative dispute resolution, in particular focusing on mediation. And this is something that your client should be considering at all times. But further than that, local authorities may well be willing to take action where the issue is particularly acute, and they often have powers to issue fixed statutory notices. It's important to bear in mind that it's usually the occupier of the land who is liable for the nuisance, so complaints directly to the landlord are unlikely to bear fruit. However, there are exceptions to that. So in particular, if the landlord has given their express authority for an action which has caused this nuisance, such as the undertaking of building works, which have caused an unreasonable nuisance, then that will be one of the exceptions. Also, if the person who is complaining of the nuisance is a tenant of a shared landlord, so for example, it's a landlord who is in control of a block of flats, and it's to do with a dispute being raised by another one of those flats within that block, the landlord will be required to step in and take action under your or client's or the claimant's tenancy agreement, and in particular the covenants to do with the expectation to have quite reasonable enjoyment. So once we've proven the case to the court, what can the court itself actually do in the circumstances? It's important to particularly note when we're discussing nuisance, we're focusing on damage which has been caused to property rather than damage which has been caused to an individual. As a result, the principal remedy will usually be an injunction in order to prevent that nuisance from happening again in future. It is possible to seek interim injunctions, and I would ask you to pay particular attention to what Oliver will take us through towards the end of this webinar in regards to interim injunctions. You can often find that damages are difficult where the interference has ceased by way of an injunction. Court will consider the diminution in the value of the property if the nuisance may affect its potential sale going forward. So if you can get an injunction to stop the nuisance, your likelihood of getting damages is significantly reduced. If the court was to find that the nuisance was something which was going to have to continue going forward, but it would affect the resale value of your property, you're more likely to get damages, but those damages would only be in relation to that loss that you would suffer in regards to the property. The court can make an award for distress and loss of amenity, but it's unlikely to be a large sum. The reason for that being, as I said at the beginning of this slide, is when we're talking about nuisance, we're mainly talking about damage to property rather than damage to the individual. That is more related to harassment, which we'll come on to in a moment. So let's look at the second potential cause of action that you can have in regard to disrepair. Now, as is noted on the slide there, this can cover a wide range of issues, such as a poorly maintained roof, which causes leaks from one property into another, or work being done in one property that has an impact on the shared party wall between the two properties. Where you have an ongoing problem, which has been caused by general failure to maintain a property, in particular, this is in regards to an overgrown garden where weeds are being caused in neighbouring properties as a result of that garden not being looked into, then this is more likely to be an encroachment claim. If a new occupier moves into a property, for example, one which has a particularly overgrown garden, the court can find that they adopt that nuisance. If they have knowledge, or the court is willing to presume that they should have had knowledge of the existence of the nuisance, if they then subsequently fail to take steps that would bring that nuisance to an end, the court will impose penalties upon them. A key point here is all about knowledge and giving somebody a reasonable opportunity once they have found out that there is an issue of disrepair to then carry out repairs and remedy that issue that has been causing the issue. Where work done has caused damage, such as a bodged roof repair causing leaks in a neighbouring property, or work being done in one property causing damage to a party wall, as we discussed a moment ago, then this is again likely to be a nuisance claim, but for direct physical injury to the property. In this case, damages are more likely to be more relevant than an injunction, because again, we're talking about damage which is being caused directly to the property rather than to an individual. As you may have noted, there is an overlap between disrepair claims and claims that could be brought in negligence, and the two of them can be argued in the alternative. An occupier of land owes a general duty of care to a neighbouring occupier, and the standard of care which is required of them will be judged on the particular circumstances. So again, we have that same question about what is reasonable in the circumstances for the court, and again, it will be a question of the notice which has been given to the individual or party which is in default and has caused the disrepair to give them the opportunity to remedy it. Moving on into our third head of loss is harassment. And a civil claim for harassment can be brought under Section 1 and Section 3 of the Protection from Harassment Act 1997. In order to bring such a claim, you will need to prove that the defendant has pursued a course of conduct which amounted to harassment of another, which they knew or ought to have known amounted to harassment. When we consider this to what we've already discussed in regards to the nuisance, you can see the difference here. This is more about damage being caused to an individual rather than the individual's property. An important point to note here is that harassment is one of those heads of claim which is often used as a sweep-up mechanism and will be argued in the alternative with some of the other heads of loss that we've discussed already during the course of this webinar. However, it's particularly important that where the actions are relatively petty in nature, it's unlikely that the police would ever want to get involved if an allegation of harassment was raised to them. It's unlikely that you will be able to get a substantial award in damages. And the problem would be if you bring a claim solely on harassment and you get a very minimal recovery from it, you may well find that you use so much time in bringing the claim and costs in bringing the claim that it's ultimately not worth it. So, Ollie, what are the other heads of lot that you can bring a claim under?
Well, moving on to some of the more sort of pure property law questions. And firstly, I'm just going to talk about rights of way. Now, they can be relatively minor in some ways, ways of rights of way, but they can take centre stage over neighbour disputes. Whether it's the exact route that somebody's allowed to drive to their property or park, even the route that they can take the bins out. But despite being in some ways seeming quite minor, they can also have quite significant impact on the livability of a property, how easy it is to do certain things while living there, and hence potentially the resale value. So although sometimes quite minor in the grand scheme of things, they can be very important to those people involved. Well, the starting point, as with anything like this really, will be to look at the terms of the grant. What does the deed or the grant of the land registry entry actually say? If the dispute relates to the route along which the right-of-way exists, it's likely to be helpful to go back as far as you can, back to the original, look at the various maps and see what's changed. But I'll come back to that issue a little bit more when we're talking about boundary disputes. But in terms of looking at interpretation as to use, Canon and Villars sets out the general rule to interpreting the types of traffic permissible under a right-of-way. So you may have a right-of-way that isn't necessarily entirely determinative as to whether you can drive a vehicle or push a wheelbarrow. It may say vehicles, what kind of vehicle? Well, prima facie, the grant of a right-of-way is the grant of a right-of-way having regard to the nature of the road over which it is granted and the purpose of which it is intended to be used. And both circumstances may be legitimately called in aid in determining whether it is a general right or a right-of-way restricted in some way. I noticed we've just had a question. We'll come at the end of this, once we've run through everything, and we'll pause and try and spend some time just answering some questions. But we'll just carry on through everything for the moment. But please do use the Q&A and we'll have a look when we get to the end. So if the court has to look at interpreting the right-of-way, they'll need to consider what the intention of the parties was when the grant was made. Not how anybody thinks about it now, but when that right was actually given. So they'll look primarily at the words of the grant, and then also the surrounding circumstances at the time. What else is there if the words of the grant aren't certain? So that will include, for example, the physical features of the land over which the right was granted. So to the purpose of the grant, just some facts and features the court may look at. If the grant provided the only way into a property, so if it's your only route to your house, then that probably more likely to include a right of access by vehicles, because if it's the only way there, clearly you're going to need to park, you may need vehicles in terms of maintenance or something like that. So if it's your only route, it's likely part of the purpose was allow you access for sort of general purposes. If you're, on the other hand, got a secondary route of access, that's what you're talking about for your right of way. For example, something quite common if you've got terraced houses or you've got semi-detached houses, a route to a garden that doesn't go through a house, so round the back or at the back gate or something like that, it's likely that was intended to provide a route to transport materials or a bike or a wheelbarrow or whatever else it might be that you may not want to store or bring through the house. So exactly what does that route allow you to access in a way that other routes may not? Court's also going to look at physical features. Does the route itself, as it was set out at the time of the grant, provide limitations? How wide is it? Is there enough room for trucks to use it or not? Are there any pre-existing constrictions like gates or narrow points or anything in terms of the surface itself that limit its usage. And all of that, the court may say, gives some indication as to feeding into and interpreting the purpose of the grant, where the wording itself is not necessarily clear. Well, let's say we've got a slightly different issue that rather than it being interpreting the scope, question is somebody wants to do something. They've put up a gate across a right of way. Well, what do I need to show before bringing a claim for interference of my right of way? Well, the leading statement of actionable interference is that taken from Lord Justice Mummery in West versus Sharp and approved in B&Q. Stated that not every interference with an easement, such as a right of way, is actionable. There must be a substantial interference with the enjoyment of it. There is no actionable interference if that right of way can be substantially and practically exercised as conveniently after as before the occurrence of the alleged obstruction. Thus, the grant of right of way in law in respect of every part of a defined area does not involve the proposition the grantee can in fact object to anything done on any part of the area which would obstruct passage over that part. Can only object to such activities, including obstruction, that substantially interfere with the exercise of the defined right as for the time being is reasonably required by him. So an issue might be here that somebody wants to put up a bollard to stop people driving over the front of their lawn or something like that. Now that may mean that you can't drive quite as close to that side of the road as you had previously. So the question is going to come, can it be substantially and practically exercised as conveniently? So how wide is the remaining part of the road? The question really being looked at in B&Q was about delivery lorries. They driving in, driving out. Was the restrictions proposed stopping them turning? Was it interfering with their delivery practices? And that was what they were looking at there, is the extent of the permission of that use and whether what they wanted to do, closing off a particular area, was going to cause a problem. So just to sort of bring this back to neighbour dispute cases, placing some restriction, such as a gate or the like, won't necessarily involve interference with the right of way. In the same way that a stile or a pedestrian gate won't provide an interference with the right of way on a walkway or a walkway you're intending to walk, and equally a gate that is opened by fob and you've got access to it won't necessarily mean that you've interfered with the right of way of somebody driving. It comes down to, have you caused significant interference? Is it less convenient to use? So a manual opening gate that you have to stop your car and get out and open it, that probably is going to be a substantial interference. An automatic opening gate may well not be. So it depends a little bit on the context. Again, the most likely remedy here is going to be an injunction. You're unlikely to be a circumstance where you're going to get significant damages. Earlier mentioned boundary disputes. So can be anything as sort of what exactly is in my garden or not. Where is the boundary between our houses? Can be more substantial. Where is the line for a field? And again, sometimes you're talking about inches, sometimes you're talking about feet, and sometimes it can be very important if somebody's trying to do a particular building project or something like that, or it may be an argument about is this particular garden feature in my garden or your garden or something like that. Again, the starting point has got to be to go back to the original deed, the original grant, where the original sale. The deed set out a contract. So your primary starting point is contractual interpretation. And where what's set out in the deed, set out in the contract is sufficiently clear, then no evidence from other sources will be permitted in order to try and interpret in a different way what's set out. So starting point is, what's the wording? What does that say? And the deeds are likely to involve a written description and a plan. So in most cases, you'll get a look at a combination of the two, but that does depend on the wording. And Lord Hoffman in Alan Wibberley Building set out the sort of the key points when looking at the construction of boundaries. So the starting point, as I said, in any boundary dispute is the deeds. But be aware that if the plan is said in the deeds to be for the purposes of identification only, then you can only place limited reliance on it. It can't be relied on as delineating precise boundaries, because that limitation is in the wording, and the fact that it's not for precise delineation, it's only identification. It's also worth being aware that if the scale on the plan is small and the line is thick, then it may well be useless for any purpose beyond general identification. If you've got a relatively thick black line that translates into something several feet wide on the ground, that's not going to be very helpful for trying to work out where the fence should go. So if you need to establish an exact boundary, you've got an argument about, where is the fence in my garden, then the deeds will almost certainly have to be supplanted by drawing inferences from topographical features existed at the time the deed was executed, or potentially from other evidence. And this is where you can start to move away from the pure contractual construction and start to try and take evidence from other sources. And obviously one sort of fairly obvious point, but certain topographical features, there's a particular rule in relation to hedges and ditches, but more general point that if you've got an obvious topographical feature that the boundary is likely to follow, you're going to end up with the presumption that that is the boundary. Primary sources of evidence in boundary disputes, again, likely to be your experts. Court likely to require a single joint expert to go down, to look, to create a properly detailed plan to the level of precision that you're going to need for the question you're trying to decide, is going to look at the deeds, is going to do their best to translate that against the evidence they find on the ground. Just a point about single joint experts. Instructing a single joint expert, if you can get agreement to it at an early stage, is likely to assist settlement, particularly in something like this where, frankly, they're likely to be determinative. There's not an awful lot of point going to court and spending a lot of money and having these arguments if you can instruct a single joint expert earlier, who's at least going to tell you where the line lies. And the caveat to that, of course, being that once they're instructed and you've got their report, it will be very, very difficult to row back if you don't like it. Because in the end, this is an expert that you, one way or another, will have chosen and said is suitable. You should have had the opportunity to provide them with the evidence that you wish them to consider, and they will have drawn a conclusion. And you're going to have to go back and either attack their qualifications, the way they've reached their decision, the fact they haven't had sufficient evidence, which in the end is going to come back to a potential criticism of you and your own behaviour. So once you've got one, you're likely to be stuck with it. So be careful in terms of negotiation, because clients need to be very aware that they're very useful tools, very good ways of reaching settlements without spending huge sums of money. But equally, once you've gone down that route, it's very hard to row back from it. So sometimes you may be better off negotiating these things out than spending a lot of money going down the route of a single joint expert, because you may not get what you want. However, beyond experts, there may be other sources of useful evidence. When you're trying to say, what is the boundary feature that you're going to be looking at, witness statements about how previous occupiers treated the boundary may be useful. Is this fence that maybe one side is saying, well, no, this was just sort of put up for some horses a few years ago, it doesn't really tell you anything. If everybody else previously for the last 20 years has treated that as the boundary, then that's likely to be quite useful evidence. Similarly, if you've got photographs, and again, photographs can go back much further than witness statements, may show the location of temporary boundary marking features. Again, fences, but could also be ditches that have subsequently disappeared, a tree that's been cut down, anything, anything like that. Other sources of more formal evidence, planning applications now can be particularly useful because they will often come with a plan. So if a party has put in a planning application that gives you some more evidence about how they see the boundary, that may well be usable against them. Estate agents' particulars can be helpful, but because they're a less formal document, less likely to be particularly determinative, and old maps of the general area, sometimes they may show you something and that may be useful. So quite a few different things that you can potentially pull evidence out of. I just want to spend a little bit of time talking about interim injunctions. The vast majority of the stuff that we've been talking about today is really about stopping somebody from doing something, whether it is walking too angrily across the floor in the flat above me, whether it's trying to blockade my way to my house, whether it's putting up nasty signs at the window. Most of the time what you're after is to ask somebody to stop doing something. And interim injunctions are a very useful tool for that, because in the end, if you want somebody to stop doing something, you want them to do it as soon as possible. And an interim injunction is a way of getting your remedy as quickly as you can without having to actually have full court proceedings before so. And the just briefly well-known American Sanity criteria: is there a serious question to be tried? Would damages be an adequate remedy? Balance of convenience and any special factors. And I'll come back to this, but really by special factors, what we're talking about is what you're asking to stop sufficiently clearly definable, set out, and would it be enforceable if the court were to make such an order? And just a note for anybody's use, applications for interim injunction governed by CPR and Practice Direction at 25A. But in terms of troubleshooting interim injunctions, we'll start there. Have you looked at alternative approaches? And again, just flag very usefully, Ian and Adam next week are going to be talking about ADR and mediation. But even beyond sort of something as formal as that, have you asked the other side to stop notification and possibility of looking at undertakings if the other side will agree them, carries less risk for you than an interim injunction application? If the application is made without notice, the applicant and solicitors have a duty of full and frank disclosure. I really want to emphasise just how important this is, because of course you're making this application at an early stage. Usually you might have asked for a certain amount of documentation, but you probably won't have done full disclosure exercises. I had a case fall apart where the claimant failed to disclose a key email where they had offered to accept money instead of the goods that they were after. And when that came out, the whole case fell apart, the interim injunction disappeared, and there were cost consequences. So you need to, if you're looking at interim injunctions, you need to be thinking very carefully about disclosure at an early stage. Has your client provided you with all the emails, text messages, and so forth, communication there might have been? Have you gone back over it and checked that you've seen all the letters and everything else? So it does require a much more proactive and a much earlier approach to disclosure. It's also worth noting that in many cases, the applicant's exposure is not just going to be costs. The court may well require an undertaking to pay damages if the injunction has been wrongly granted. In many cases, perhaps not so much of an issue. If your injunction is to stop your neighbour blocking your drive, it's unlikely they're going to be facing, it's going to cause them enormous problems if they're told not to do that. But you could have cases where the damages could be quite substantial. If you're asking to prevent an event taking place or something like that, then your exposure could be quite high. So be aware when you're looking at interim injunctions that it's not just a cost consequence, but it also could be damages if the injunction has been wrongly granted. So it comes back to make sure that you have looked carefully at what your case is. Draft order must set out terms which are specific and enforceable and include a penal notice. This is the point that I mentioned earlier. If you're looking at harassment claim, and though arguably, of course, you can draft injunctions not to harass and so forth. You see them all the time in crime and family. But far more likely and far more useful are going to be things specifically like not to put up notices referring to the applicant, not to knock over the applicant's bins, and not to park your car across the applicant's space, something like that. That is easy to say when it has and has not been complied with, easy to say what its scope is, which makes it specific and enforceable, and therefore far easier for the court to allow and far easier if you have to enforce the penal notice. For many interim injunctions, I'm not going to talk about ones where affidavits are required, but most of the time you can do the evidence in the application notice. But I think as a matter of good practice and as a matter of sort of thinking through things, drafting a full witness statement in support is a good thing to do. Comes back a little bit to making sure that you're clear as to what your case is and that you've complied with a duty of full and frank disclosure. If you're setting out things long form in a witness statement, you can be at least reasonably sure that you have covered everything with your client because you've had to do it in order to get the witness statement drafted. Note that if an application has been made without notice, that you need to explain why you've made it without notice. One explanation can be that the sheer urgency requires it to be made without notice. You have discovered that your neighbour is due to have a death metal rock concert in the field next door to you, and you've got 16 babies all sleeping in your house or something. That may be a ground that you need that quickly because you need to stop it. But the more common reason it's going to be made without notice is because fear of retaliation. So if you've got a case where your neighbour was stomping around upstairs and you said to them, please, can you stop? And as a result, they then started to play rock music or perhaps classical music very loudly at 3 a.m. or something in retaliation, then obviously you would be concerned about what would happen if they were to receive papers from the court saying you wish to bring a claim against them and are seeking an interim injunction. You'd fear retaliation. So in that sort of circumstance, you may well want protection from the court before the other side are notified what you're doing. But whatever your reason is, if you're making your application without notice, you need to be explaining why you've made that application without notice. So I hope that brings together a little bit in terms of remedies and sort of some practical considerations the various areas we've been talking through. We anticipate that just as with the family team we've been talking about divorce, that as you've got people who are living in very close proximity, people are going to be winding each other up, and therefore this may well be an area that as things start to loosen up, people have slightly different considerations on their mind. This may well be an area where there's some work coming through, and hence may well be hopefully a source of instructions and work coming through to you. So we hope this has been useful. We've talked about the ADR talk that's coming. I'd also noticed, because of course we talked a little bit, or touched on harassment and of course potential for criminal harassment proceedings, that Adam Gersh and Anthony Metzer QC are going to be doing a talk on private prosecutions coming up as well. And that's something that can come out of neighbourhood disputes as well. If you really want to take things another step, if it's got really bad and the police aren't becoming involved, that may be something that your client may need to consider. So I hope that's been useful. I can see we've got 1 or 2 questions just popping up, so we'll endeavour to answer a few of those.
Thank you very much, everyone. I note that we have run over time by a bit. Thank you very much for bearing with us on this lovely Friday afternoon that we have. The first question which has popped up is to ask what's the difference between Section 1 and Section 3 of the Protection from Harassment Act 1997. So I won't ask Ollie to go back to the slide in which we had the note on harassment. So I'll just read from the slides that I have in front of me. So we said that you would need to prove that the defendant pursued a course of conduct which amounted to harassment of another and which they knew or ought to know amounted to harassment. That is effectively Section 1 of the Protection from Harassment Act, with the additional interpretations that come under Section 7 of the Protection from Harassment Act. Now, the reason why we mention Section 3 is because it's Section 3 which actually grants you the ability to have a civil remedy as a result of potential harassment. And reading directly from Section 3, it states an actual or apprehended breach of Section 1 may be the subject of a claim in civil proceedings by the person who is or may be the victim of the course of conduct in question. It goes on to state, on such a claim, damages may be awarded for, amongst other things, any anxiety caused by the harassment and any financial loss resulting from the harassment. Which is why we said in the slide that it's Section 1 and Section 3, because ultimately Section 3 allows you to bring a claim under Section 1.
Section 1's the test, Section 3 is the entitlement to damages. Otherwise, it's largely a criminal act or criminal legislation.
Questions just popped up about the diminution in value of a property. What's the best evidence to obtain? Well, ultimately, this is where your links to nearby estate agents will come into play. Most estate agents, if they think they are potentially going to get a sale from the property, will be willing to assist in setting a valuation for a property in order to work out what the difference in value will be. Most estate agents will be experienced enough to be able to provide you with two separate quotes. In many circumstances, if you're looking to buy a property and the person who is selling the property is considering doing work to the property before it's sold, they will be able to work out what the difference in the values would be. Certainly, that would be the easiest way of working out what that diminution in value is likely to be. If you can't, the likelihood is the court themselves will need to work out what the diminution in value is going to be in order to work out what the value of the overall claim is going to be.
Yeah, and sometimes you can get evidence from surveyors, but often, frankly, local estate agents can be a decent source of evidence. They're also going to be cheaper than instructing a surveyor. It depends a little bit how much money you've got and what sort of thing you're dealing with. If you're talking about something very substantial like flood risk or something like that, then you may well be wanting to look at a surveyor. If you're talking about noise and a slightly more noisy property or something like that, then you might well be looking at local estate agents. And we were just asking about penal notice in the draft injunction order. It's just the standard form penal notice. In the end, the point being really that if you want to be able to enforce your injunction with a contempt citation and look at the court trying to send somebody to prison, you're going to have a penal notice at the end of it. And remember that unless it's waived, if you want to look at those sort of proceedings, then the order has got to be personally served. So just be aware of that. So as where the line between civil harassment and criminal harassment, there isn't really a specific line. You may well have a claim under both. It's not really there's not really an either. It's not really an or. It's an either. Civil harassment will result in damages. Criminal harassment may result in compensation, but is more likely to result in criminal sanction. So it's not a sort of one or other, but it may well be both. Also, a bit of a question of how far are your police going to be involved and interested is really where that falls over. I received just a question in relation to private prosecutions, and we will send out hopefully the invite will go out this evening. If it doesn't, it will go out tomorrow with the letter with the various links in. If not, where you found this talk on Eventbrite, they will all be up there, and it's exactly the same system to click through. All right, I think we've got through most things. If anybody's struggling to find a link, if there's a talk that you'd be interested in that we haven't done, if there's a seminar that we've mentioned that you can't find, then please speak to our clerks. The general number and website are all up and running, so please ring or email and somebody can point you in the right direction. Thanks very much. Have a good afternoon, and I hope you have a lovely weekend.